Welcome to a Zoom session of oral argument for the 5th DCA. It's 11 o'clock, case number 19-641. The case name is Patricia Persicilli. I apologize if I mispronounce her name, versus Nicole Marie Castro Reyes. I'm Judge Lambert, presiding judge. With us today are Judge Eisnagel and Judge Harris. Again, each side, it's a civil case, each side will have 20 minutes. Mr. Barnes, we will set 5 minutes aside for rebuttal. If you want less or more time, just let me know at the start of oral argument. And again, we are being streamed on YouTube, so anything you're saying, whoever might be interested in watching this will be able to hear your comments during oral arguments. So just keep that in mind as you make your presentations. So that being, and Miss, how do you say your last name again? Cabulea?
Cabulea.
Cabulea?
Yes.
Okay. Okay, ma'am, Ms. Cabulea, if for some reason you can't hear us as we go through this, let everybody know, okay? If we don't hear from you, we're going to assume that you've heard us all during the arguments then.
Sure, I will do that, Your Honor. Thank you.
Thank you, ma'am. All right, Mr. Barnes, if you're ready to proceed, go ahead, sir.
Yes, sir. Good morning, justices. My name is Stephen Barnes.
Well, we're not justices, we're judges.
Yes, Your Honor. I represent the appellant Patricia Persicilli in this matter. We are going to request, after a de novo review of this, that the court find the non-monetary terms of the proposal for settlement, specifically the hold harmless and indemnification agreement, were ambiguous and lacked the requisite specificity for a non-monetary term in violation of Rule 1.442, and ultimately ask that the court reverse the final judgment awarding attorney fees and costs in this matter. The language of the release can be found at page 999 of the record, and I believe it's page 3 of appellant's brief. The language is underlined in our brief at page 3 that we believe is offending. As we go through this, Your Honors, I would ask that we, analyze it under the umbrella of well-recognized principles of law within the 5th District. First of all, it is very clear that Rule 1, and this is from the Supreme Court case of State Farm v. Nichols, the 2006 case cited in the briefs, and there's cases cited within the Nichols case. And they clearly established that Rule 1.442 requires that proposals for settlement be sufficiently clear and definite. Those are very important terms to allow an offeree, my client, to make informed decisions without the need for clarification. That's incredibly important because as I go through this, we're going to point out to the court why this specific hold harmless indemnification fails in that regard. We also need to remember that a proposal for settlement is intended to end judicial labor and not create more. And we cited in our brief Judge Casanueva's reasoning in a concurrence as to why non-monetary terms create problems such as this. We also need to recall that a proposal for settlement does not satisfy a particularity requirement if an ambiguity within the proposal, in this case, they've attached a release that has a hold harmless indemnification, so that's part of the proposal, could reasonably affect the offeree's decision. And we will point out to the court how the ambiguity and lack of specificity has grave potential consequences for our client that she could not appreciate and evaluate at the time the offer was made. We also need to remember that the rule is strictly construed and ambiguous proposals are unenforceable. These are clear.
What counsel, looking at the provision.
Yes, sir.
It's quite broad.
Yes, sir.
Is it your position that a broad provision is, because it is broad, it is therefore ambiguous?
No, sir. I don't believe we can under current law make such a strong statement that simply a broad provision by definition is ambiguous. I think we have to look at the terms and try to figure out what the breadth and the scope is and whether it's ascertainable.
When we read this provision, what exactly is unclear about it? I mean, other than it is incredibly broad. I think we can all agree on that. But what is unclear about it?
What's unclear is the nature of the claims or demands that exist that my client would be assuming legal liability for if she were to accept this offer.
So it's your position that the indemnification provision would have to specifically identify every claim that it could apply to? It can't just say all claims?
I don't believe an indemnification provision to be enforceable can simply say all claims and end it there. And what we pointed out.
Well, it doesn't say all claims and end it there, right? It says it essentially says all claims in any way growing out of said occurrence or its results both to person and property.
Correct. And the law within the 5th District says those terms have to be clear and definite. And our position would be, if I may give the court some examples, when you talk about any and all claims or demands whatsoever on account of or any way growing out of the occurrence or the results of the occurrence, what does that mean? Does that, and remember, this is my client being required to indemnify not only the defendant, but her insurance company as well. So does that include a subrogation claim? Liberty Mutual may suffer from another insurance company? Does it include the defendant's medical doctor saying that they have a claim for her treatment from this accident? Does it include attorney fees that she may not pay her attorney that arises from representation in this? Does it mean fees between the attorney and the insurance company? Could it be read so broadly to mean that as a result of this accident, that's a disputed liability accident, the potential that her insurance company raises her premium and wants more money from her, my client's got to pay that? Arguably, the breadth and scope of this could be read to that degree. And what the error here, okay, Judge, they don't have to attach a release to a proposal for settlement. They can ask for a dismissal with prejudice and settle the claims as between the parties. If they want to go to a settlement that includes a release that has these broad terms, it doesn't need to be a proposal. That can be a straight offer to them where the parties negotiate the terms and there's bargaining power. And we cited in our brief why that's important. They're almost trying to put a square peg in a round hole by including something that's so broad in a proposal for settlement that it by definition creates a problem with specificity and non-monetary terms. We cited
Counsel, going to the increase in premiums argument you made, would that be a claim against all claims and demands?
It could
an increase in the premium, would that be reasonably interpreted as a claim or demand?
And I believe it could reasonably be interpreted as a demand. However, the need to interpret that should not be imposed upon my client. The case law says that, and we cited it within our brief, that the burden of clarifying intent or scope of a proposal for settlement cannot be placed on the offeree. That's Dryden versus Piedamonte, 5th District case from 05, 901 Southern 2nd, 854. So where the failure was here was from the beginning when this offer was made. We can't impose that on my client to start to interpret what the scope or breadth of this may or may not be. It has to be clear on its face. And here's the danger.
If there's one reasonable meaning, then it is clear, right?
If there's one reasonable meaning of all the terms and the breadth and scope of the hold harmless, it could be. Absolutely. I agree with you. However,
I'm just trying to, I mean, an increase in a premium doesn't strike me as if we read the entire provision in context, it doesn't strike me as a claim or demand as those terms would be used in a release.
Well, the terms are not defined within this release, nor the hold harmless indemnification. So they've got to be read as broad. And in the hearing, defense counsel argued they wanted this to be as broad as it humanly possibly could to encompass everything. So arguably, by that reasoning, if that was truly their intent, a demand could very easily be a demand for money. It doesn't have to be a judgment or a lien or a subrogated right. It can be a demand for something. It could open my client up to somebody sues the defendant or her insurance company later on, and she's got to hire an attorney and pay them fees. And suddenly my client's taken on the liability of paying her attorney to go fight somebody that's claiming some type of claim or right as a result of this accident. That's where the breadth comes in. And the reason we pointed to the Florida Bar form release and the trial lawyer section of their website is that has both indemnification and hold harmless agreements for liens as well as subrogated interests. And they're still broad. They still talk in terms of liens and subrogated interest for things like work comp, disability, health insurance, Medicare, Medicaid, payable to the release or my client as a consequence of the occurrence. So you can still have something that's broad in scope, but is not unclear and ambiguous as to what the liability would be. This is not simply my client saying, okay, I'm going to broadly release all the claims I have against the defendant. Okay. This is their requirement that my client take on unknown, unidentifiable legal liability. Those are apples and oranges. That's the failure here. Arguably, if they had omitted this hold harmless indemnification agreement, this may be an enforceable proposal. I haven't analyzed it from that perspective, but arguably it could be. But when you go further, and we've cited the cases of why an indemnification and hold harmless agreement are not a release, they're a different animal. When you go further to impose liability on somebody, I'm of the position you can't do that with a proposal for settlement because you run down the path of non-monetary terms. But if we assume,
well, but counsel, I mean, if it was this court's authority to write the rule, maybe that's a decent argument to make to this court. Maybe your argument would be, gee, the rule shouldn't allow non-monetary terms, right? But we're bound by the rule, and the rule says you can include non-monetary terms. Yeah,
and if that, I didn't mean to communicate that and I misspoke. I believe you can include non-monetary terms. I believe
you absolutely can. The rule says it, and it's not this court. This court doesn't have authority to change that.
Oh no, I agree with you 100%. My distinction was hold harmless and indemnifications that are so broad in scope like this, I don't believe belong in a proposal for settlement. I believe you can have non-monetary terms. Absolutely 100%. The case law says that, the rule says that. However, they are disfavored. And we have pointed out in the brief, I believe on page 14 of our brief, and Judge Casanueva's comments in the Dryden case, why non-monetary terms are disfavored. And if they're going to be used, it's
Counsel, what if the language was a little different? What if it said from and against all claims and demands whatsoever arising out of said occurrence, period?
Judge, I believe that's still impermissibly vague because it hasn't defined what legal liability my client's taking on. She doesn't know what exists out there against.
Well, isn't that your job as the lawyer to tell her what exists out there? I mean, why is it their job as the party submitting the offer to essentially provide legal advice to your client and tell your client, hey, here's all the different ways this could raise liability?
It is not my client's job. And yes, I have a responsibility to advise my client, but I have to be able to understand and clearly know what exists by way of legal liability so I can tell her whether to accept this or not.
Well, I mean, if it just said all claims and demands arising out of the occurrence, then the answer to that would be everything arising out of the occurrence, right? I mean, you could, as a lawyer, you could make a list of examples of things, but I mean, the point is that it would be very clear at that point, it's everything. It would be incredibly broad, and it would include every single thing that could arise from the occurrence. Why is that ambiguous?
And again, if it was me advising my client, hey, if you accept this, and it was a release, you have to release them from any and all claims you have, anything you could possibly include in this lawsuit, 100% that's permissible. And I had the ability to run through with her all of the repercussions of that. But when you impose a hold harmless and indemnification that broadly, that's imposing legal liability, I don't have any way to counsel her on what she would or wouldn't be accepting. I don't know if there's mechanic liens out there on a car that was.
But you could advise her there might be a mechanic lien.
Agreed. The might, though, lets her know it may exist, but she can't make a reasoned decision. Do I accept this small amount of money and potentially expose myself to endless liability? I don't know what that liability is. I can't weigh those options and make a rational decision. That's where it needs to be more specific. That's why the Florida Bar indemnification agreements point to things.
What if the provision said that your client would indemnify from all mechanics liens, but doesn't say what third party has a mechanics lien, but it said any mechanic lien out there, you're on the hook for it.
Arguably, okay, if that happened, okay, and I want to advise her, okay, I believe it's impermissible because what it would require me to do is pick up the phone and call the other side and say, hey, you put mechanics lien in here. Tell me what this is and how much it is. The case law says we don't need to do that. And if we have to do that, it's invalid. The burden is on the other side to make that.
So it's your position that they have to list, they have to list every single specific third party. So for instance, if they were to say, a claim, they couldn't just say doctor's claims or medical claims of medical professionals. They would have to list the very specific medical professionals and entities that have claims.
No, sir. And if I've communicated it to you, I apologize. That's not my client's position. And I'll read to you what I think is a fair indemnification.
Well, you just said that they would have to identify who has the mechanics lien.
No. For me, under your scenario, I would have to make a phone call to find out what the amount was. But we're not taking the position everything has to be identified. There has to be sufficient specificity so that the offeree can make a decision. For example, if it read, the releasor will protect, indemnify, and save harmless the releasees from any valid claims or liens arising from the benefits provided to or on behalf of releasors, which are related to the incident giving rise to this claim, including federal government, Medicare, Medicaid, insurance companies, physicians, healthcare institutions, and any attorneys previously employed by the releasor.
It's your position that just saying insurance companies without identifying the insurance company or the amount, that's sufficient.
It is, because there's a provision that relates that to benefits provided to my client. So it defines, hey, look, if there's an insurance company, an attorney, Medicare, Medicaid that's provided you benefits, okay, we'll know about that. You got to hold them harmless and indemnify. That's permissible. But to define it that any liability against the offeror, in this case, Ms. Reyes or Liberty Mutual, some unknown claims that exist, we've got to hold them harmless and indemnify. We don't have any way to know what those are or evaluate them.
All right, counsel, you got 3 minutes or so left. You want to save that time or keep going?
I will save the time, Your Honor. I appreciate it.
Okay.
Thank you for the questions.
Okay. Go ahead.
May it please the court, my name is Mihaela Cabulea, and I represent the appellee, Ms. Nicole Marie Castro Reyes. Your Honors, can you hear me all right?
Yes, ma'am.
Okay, thank you. Your Honors, I would like to make 3 points regarding the appellant's argument. First of all, the trial court in this case got it right. If you look at page 1183 of the record, the trial judge went through the specific terms of the indemnification clause and analyzed them and found that each and every one of them was specifically defined. So the judge concluded at the end of his reading of the clause that we really know exactly what types of cases are released, what types of claims are released. To wit, all the claims and demands arising out of personal injuries from the December 23, 2013 accident. That is clear. Furthermore, the trial judge also noticed that there is a carve-out provision that is absent from appellant's initial brief or reply brief And that carve-out provision excludes past and future medical expenses. So we know here that those are not at issue, and Ms. Keeley is not on the hook for any, can pursue those claims as she wants. Second of all, appellant in this case has not identified any concrete ambiguities. Everything that we've heard from appellant so far.
Counsel, I have a question for you, if you can hear me.
Yes.
With this indemnification provision, let's say that this was a 10-car accident, and would this provision release the claims for personal injuries made by some other plaintiff not involved in this case against Mrs. Reyes?
So to answer your question, Your Honor, potentially yes, because this particular provision was not designed for multiple attorneys, multiple claims, and this is exactly my point. There's no specific ambiguity related to the facts of this particular case. If you look at all the cases that were cited to by appellant, they all have identified a specific problem and ambiguity based on record evidence. For example, in the Dice case, there was potential release of medical claims as well as of the PIP claims, and the court found that that's ambiguous. In our case, there's no such problem because medical expenses are clearly excluded. In the Dryden case, we had the settlement was ambiguous because it was unclear whether PIP benefits claims would be released or health insurance claims. Again, we don't have that problem here. In Brenner, there was a problem with the language was too broad regarding to the plaintiff's counsel, who was also required to sign the release, and there was no signature block for the counsel. Therefore, the appellate court found that that was fatal to the release and it was ambiguous. In Sparkling, the same problem. There was the release was found to be ambiguous because there were multiple defendants, and this covers your scenario, Your Honor. Multiple defendants, many of whom were bound together by the concept of privity, and two of whom were insured by the same insurance carrier, and it was unclear whether the claims would be released as to all of them, both of them, or just as to one. And I can go on, and the Nichols case is similar. It also had a PIP claim and an uninsured motorist claim, and it wasn't sure. The language of the release was so ambiguous that it was uncertain whether both claims would be released or just the PIP claim. So in each and every one of these cases, there is a specific ambiguity that affects the person's understanding of the release at the time the proposal for settlement is made. Here, we have nothing in the trial court while the hearing was held. We have nothing here on appeal. It's just hypothetical problems. And some of the hypothetical problems don't even apply, like the medical doctor that was mentioned by my opponent. That's not an issue. Those claims are not being released. We have it in the carve-out provision. So basically, just because it's broad, there's no authority to invalidate the provision. Broadness is not the issue, whether it's ambiguous. And here, there's no specific ambiguity being identified in the record, in the evidence of the case. So the other point that I would like to make, Your Honors, is that this is the quintessential case in which a valid proposal for settlement should be upheld and should be enforced. The purpose of the statute is to avoid litigation and to costly litigation and to basically save resources of the court. But if we look at the proposal, it was made in good faith. It offered almost $33,000. And on the other side, we have the plaintiff who decides to go to trial, cannot even prove a permanent injury, and cannot even prove damages in the amount of $3,000. So I would ask this court to find that the proposal was obviously valid. I would like to also address a couple of the arguments made by opposing counsel in terms of the model form for proposal for settlement of the Florida Bar. There is no, I want to point out that even that form that's proposed by the Florida Bar has sample claims that are being released, but the form itself says including but not inclusive of all the types of claims that are being released. So that form too is equally broad, and just because our form doesn't specify some of the claims that are being released, it doesn't mean it is invalid. And the other point I would like to make, as Judge Eisnagel pointed out, it is not for this court to change the law, but it is to apply the law. And maybe Judge Casanueva had a good point in his concurring opinion about non-monetary terms, but he himself decided that it's not for him to legislate from the bench, except to express his disagreement with some of these non-monetary terms. As the law stands right now, the law allows for non-monetary terms for as long as they're specific and not ambiguous. And here they're broad, but other courts have upheld similarly broad indemnification language in the proposal for settlement. There's no other problem identified by appellant with the proposal for settlement. There's no allegation that it's not in compliance with the statutory requirement or the rule, but just that it could not, it's so broad that it could not allow counsel to make a determination as to what is being released. Well, clearly, medical claims are not being released, and it's all claims and demands arising out of the personal injuries only, and as to arising out of the occurrence, the accident that took place in 2013.
Did you know that Judge Eisnagel used to be in the legislature before he was on this court? So does he get to legislate from the bench since he wore both hats?
Well, that's a good one, Your Honor. I think you
I'll
might
answer
want
that
to
one
go
for
back.
you. The answer's, counsel, the answer's no.
There you go. What a surprise, eh? Well, I just pulling your leg. We all understand that separation of powers, and we don't legislate from the bench. That's for other entities to write the rules in the statute. So go ahead.
So I think I did make all the points that I really wanted to make, and if Your Honors have any questions of me, I would like to answer those.
Judges? No?
Nope.
And if not, thank you for your time, and also we ask the court to affirm the trial court's correct ruling in this case. Thank you, Your Honor.
Thank you, counsel. Okay. Mr. Barnes, you have, looks like 303 left. Go ahead, sir.
Yes,
Well,
sir. Thank you.
if you could hone in on the one issue here that seems like it's risen to the top. In your brief at page 10, you argue that this provision is unenforceable because it subjects your client to quote, unpredictable and unquantifiable risk. It seems like unpredictable and unquantifiable risk might flow simply from the fact that it's a very broad provision. And that might be different than a provision that is ambiguous or unclear. And in other words, it seems like there's an argument here. This provision is very clear. It is incredibly broad and requires your client to indemnify for everything that could arise out of the occurrence. Why is that? Why is the fact that it's unquantifiable risk, why is that the same thing as ambiguous?
Because we're in a setting where it is a take it or leave it. This is not a negotiation where each side can negotiate the terms, inquire about the terms, do some due diligence and investigation to figure out what's going on and what type of liability is potentially being imposed. This is a one-sided, here's the offer. And the case law is very clear within the Fifth and throughout the state. When that happens, if the defendant, or I'm sorry, if the offering party is going to do that, it is incumbent upon them to identify those things so a fair evaluation can be made. If somebody can simply say, and part of the problem is they're conflating a release with an indemnification. A release analysis is totally different. Indemnification that imposes liability on another party, if they're just going to say, hey, it's everything on the face of the earth, that by definition in a proposal for settlement setting is impermissibly, it lacks specificity.
If
and
they
is
had
not
said
properly-
every insurance, a claim by every insurance company arising out of the occurrence, that's still an unquantifiable risk, is it not?
Correct.
So why is that okay, counsel?
I don't believe it is okay.
Oh, I thought you were making the argument that if they had put this list of things, Medicaid, Medicare, the federal government, insurance companies.
It is, but that's not the operative language that makes it clear and unambiguous. The fact that it's related to the incident and pertains to benefits provided to the plaintiff, the offeree, that's identifiable. We know the universe they're talking about. It's companies that are providing a benefit to the person being made the offer. We can evaluate that. But when it just broadly says everything out there in the world, that is impermissibly unspecified to where
Everything in the world arising out of the occurrence. I mean,
Correct.
it's not just everything in the world, right?
Well, everything arising out of the occurrence or that results from it. That was in the indemnification. So it's not just the occurrence, which is vague. It's anything that resulted from it. And that is even further down the road.
Okay, counsel, thank you. Your time's up. All right. Thank you very much for your arguments this morning. We'll stand adjourned.
Thank you for your time, Your Honors. Have a good day.